Hello, this is Court Watch with Alex Sawyer, and I'm excited to bring you the third episode of my podcast where we will be talking about the Supreme Court's major affirmative action cases argued last week and discuss the implications of a ruling from the justices striking down race-based classifications. Race is also the topic in another case being heard this week over adoption rights of Native American children and non-Indian parents. Here to break it all down with us is Ilya Shapiro, Senior Fellow and Director of Constitutional Studies at the Manhattan Institute. He's got some expert analysis on how the High Court's affirmative action ruling could break down. Hey, Ilya, thanks for joining the podcast today. I guess we should start out by saying the affirmative action cases involving Students for Fair Admissions and their claims against Harvard and UNC over considering race as part of the application process for admissions was heard last week. The arguments were quite long. I was in the courtroom and I had to kind of leave right towards the end because, once you leave, you can't go back in. And it was about 5 hours. You had to go to the bathroom. But it sounded to me like the majority of the justices were repeatedly asking, when does this type of consideration end, right? When does race not become a factor for achieving, diversity for a class? And it seemed like the universities, they had a difficult time answering that question. So I know the reference was the court's ruling from 2003 upholding affirmative action. And I believe it was Justice Sandra Day O'Connor who said, I hope race wouldn't be considered in 25 years from now. So we're not too far away from that. And I guess I was curious after listening to arguments what you thought. What was your take? Do you think that we are going to see an end to affirmative action?
Yeah, good to be with you, Alex. I think that what you point to is one of the key aspects of the case, of the argument, the end point idea. That was asked by several of the justices, including, importantly, Kavanaugh and Barrett, who are thought of as the key votes on this. John Roberts seems to be firm against the consideration of race. This is unlike other areas. I think Roberts is not the kind of squishy swing vote on this particular issue. But you're right. It was telling that neither the UNC lawyer nor Harvard's lawyer nor the U.S. Solicitor General were able to identify not just a number of years, but even what the metric would be. What would need to be hit or as evidence that racial preferences could be sunset or moving towards ending them. And I think that was unsatisfying to a majority of the court. The fact that it's basically the argument is we will forever need racial preferences. That is not going to satisfy the court. And so indeed, I think we're headed to the end of, we have to be specific in our terms, the end of using race as a determinative factor, of giving a preference based on race for university admissions. Affirmative action, I think, is more broad than that. You can have outreach. You can have programs to make sure that you're getting different kinds of backgrounds, maybe socioeconomic diversity, maybe experiential diversity. Who knows? The issue of immigrants came up. Maybe that kind of background will be considered. But in terms of racial preferences, I do think the court is going to end that.
Yeah, and I guess, do you think, you mentioned a few different socioeconomic, I know in Texas, what was brought up was the top 10% rule, where if you're in the top 10% of your high school, then you get to be automatically admitted to, a state university of your choice. Do you think something like that could work on a national level?
Well, the universities are governed state by state. There are no national universities other than the military academies, of course. And I think different states will try different things, and I think private institutions will try different things. The Fisher case, the challenge to UT Austin's top 10, which is now I think top 8% program, passed muster. There were two cases before the Supreme Court in 2013. Fisher won. The court said judges really have to scrutinize what administrators are doing. They can't just take their word for it. And then in 2016, after scrutinizing what UT was doing, they okayed that. So I guess having that kind of regional diversity or getting after remedying de facto residential segregation. There was some confusion by Justice Sotomayor over the difference between de jure, meaning by law, or de facto, meaning in practice. Those kinds of programs are okay, the court has said, and in overturning racial preferences, that doesn't necessarily have to be overturned as well. So I imagine there is going to be, in addition to massive resistance from the educational establishment to getting rid of racial preferences because they're really invested in them. But in addition to that, I think there's going to be experimentation of getting rid of legacy preferences while at the same time expanding geographical preferences, socioeconomic, these kind of top X% programs. I think they're going to try, perhaps I have some faint hope that they'll try to get at actual diversity rather than what commentator David Latt has called visual diversity, where you have a Benetton ad where everyone thinks the same.
Mm-hmm. And so I know you and I have talked in the past about secondary education, like the case pending, I think it's before the Fourth Circuit with Thomas Jefferson High School. If the court were to strike down affirmative action, with these universities, would it in turn then have implications on secondary education? What's going on in some of these high schools, for example? I know the claim with Thomas Jefferson is the same that we heard from Students for Fair Admissions with it's interesting, in the past there's been white plaintiffs, and here you have Asian Americans saying that, we're the group that's being discriminated against.
I think it would have ramifications. The governing laws over K-12 aren't always the same as for higher education. And in this context, there are not that many schools that have that are public schools that are selective. There are some in terms of charters, and there's get into complicated governance issues. But Thomas Jefferson is an interesting case. It's out of Fairfax County, Virginia, not far from where I live, and for a long time it had one of the strongest reputation in the country, particularly for STEM education. But the thinking was by its administrators that there were too many Asians, and so they got rid of entrance requirements. And it's a big mess, part of the COVID era revolt by parents against school administrators and school boards and so forth. So I think certainly in this context, if you're purely using racial preferences or having programs that are thinly veiled pretexts for having racial balancing, that definitely is going to have an impact on cases like TJ's.
And I think I saw it was like or maybe it was in September when the Fourth Circuit had its arguments. Is there any estimate on, do you think that they're waiting to see what the justices do before they issue their ruling?
I don't know. It's kind of tough because it's been already a long time since the argument, and the Supreme Court probably won't rule in this case until June, although it could, if the opinions are clear-cut, it could come earlier, but it would seem to be an extra long time for the Fourth Circuit to just sit on that. But they could, out of an abundance of caution, out of prudence, knowing that the Supreme Court's about to determine certain things. There's no way of forcing any court's hand as to when it's going to rule.
And then I should know this. I think it's been a few months, but isn't there also a case in Montgomery County similar with a high school there and the admissions, application process, similar claims?
I've heard about that. That does ring a bell, but I don't know the specifics.
Yeah. It just seems, I know, different high schools operate in different ways. Not very many are with this sort of application system, at least not where I grew up. But it seems like it is more, I guess I don't want to use the word widespread, but it could have, there's different things like, your locality, you could hear of a different school, a various school, whether even, I guess, with private, depending on how Harvard's case comes out, having to change its application process. So it's something I'm obviously following, not just from the Supreme Court, but lower courts too.
With private schools, let's just clarify this. So Harvard and UNC were sued by Students for Fair Admissions. These schools were chosen because they're the oldest private and public universities in the country. And, some might think, well, what, Harvard is private. Why does it have to abide by federal, it's not a state actor? Well, under Title VI of the Civil Rights Act, schools, educational establishments that receive federal funding are treated the same for purposes of civil rights laws as state institutions. And so the standard under the 14th Amendment, currently under the jurisprudence, is the same as for Title VI. It's quite possible, actually, that the Supreme Court could decide this issue for both schools, for both Harvard and UNC, under Title VI without reaching the 14th Amendment question. in which case Congress could amend Title VI and specify exactly how race can and can't be used. But in any event, that's certainly similar for K-12 institutions. So to the extent that they receive federal funding, they're subject to federal regulatory strings. But if they don't, then there's more leeway in how they have admissions practices.
And then real quick, I know that Title VI, it came up, I think Justice Gorsuch brought it up a lot. But then also, I haven't talked to you since Justice Jackson has been, I guess, maybe I have talked to you. I don't know. I haven't had a reaction from you about how Justice Jackson, her presence is on the court. And then I wanted to ask you a follow-up to that, specifically about these affirmative action cases. She recused from the Harvard case because she had been on the board of overseers, but she was definitely present during the UNC case. What did you feel like her voice added anything to the argument, and like what happens with her being recused from one but not the other?
You know, she's been engaging in a bit of what I like to call prog-splaining, where progressives try to explain originalism or other concepts by conservatives and don't get it quite right. I don't think her presence in the UNC case and absence in the Harvard case is going to make much of a difference. The cases were unconsolidated precisely because she was recused from Harvard because she had been on the board of overseers there, and so she did participate in the UNC case, and as has been the trend so far, spoke more than anyone else. But I think all that means is that the Harvard case will be 6-2, and the UNC case will be 6-3.
Mm-hmm. Okay. I guess I'll also mention before the arguments took place, I did an interview with Edward Bloom, the president of Students for Fair Admissions, and one thing he said was, that he hopes these cases they go beyond college applications and basically like end checking a race box for throw something idea out there like job applications, mortgage applications, whatever. And so I guess I thought I'd ask you, one aspect of that was the Biden administration, the Solicitor General's arguments in favor of affirmative action was focused on the military, really. And she had said the diversity is needed in the military for national security reasons. The other aspect was that you want to see diversity in the ranks, so you see a pathway to climb up. I wanted to get your take on that and how it was received by the court. There was one part where I remember the Chief Justice kind of was like, are you asking the Solicitor General if she's going to stick with basically rising or falling with the universities in terms of the military argument. Did you find that unusual, or what do you think of that?
Well, it's not surprising that the Solicitor General would focus on that. In the University of Michigan cases in 2003, the brief on behalf of military officers as well as corporations were very influential for the justices, and certainly the court tends to defer to considerations of national security. I'm not sure it was very convincing because, of course, the military recruitment process can work separately from what colleges are doing, and if there's not a lot of military capable, racially diverse candidates from Harvard or UNC, they can go to other schools. They can promote within the ranks with officer candidate training and so forth. So I don't think that issue is going to this time change the court one way or another.
Right. And I don't see a way for them to separate the court that is the 14th Amendment, for example, claim for universities versus military. Wouldn't it be? It would have to be the same.
I think that's right. It's a government actor, and for anything, the military could, in governing itself, could have more leeway than university actors because there's issues of national security. That would be a separate issue. But here, it's arguing military issues by proxy of university admissions. After all, this isn't about the promotion decisions or training or what have you within the military. This is about trying to justify admissions at these schools. And of course, not all military officers come up through ROTC at these various schools. Not all schools that practice racial discrimination, racial preferences have ROTC programs. So it's an inexact fit for the kind of argument. But again, understandable given that the UNC and Harvard lawyers already spent significant time in their argument on addressing the central issues that the U.S. government would focus on this area that was quite influential 20 years ago.
Mm-hmm. And then I started covering the Supreme Court in 2017. I know you've been watching it much longer than that, so I thought I'd get your thoughts on this. So as we're sitting here today, a few more cases are set to be argued this session. So one of them is Wednesday, the case involving the Indian Child Welfare Act. And basically it's, for our readers who aren't familiar with the case, it's about white families or non-Native American families wanting to adopt Native American children. And this federal law basically attempts to keep Native American children within their tribal communities. So it's another interesting case that looks at, I guess, race and identity. On top of that, I was thinking we had last month, it was the voting rights case out of Alabama. It dealt with, allegations of racial gerrymandering with their congressional map. Is it just me, or do you think I guess my question is the court taking up more cases that deal with like race and identity? It just feels like already there's 3 cases and it's only November that hit that topic. And I don't recall seeing that many, I guess, this soon in past terms. Is it like, am I imagining this?
You have to look at the statistics. It's, last term had a number of blockbuster cases in various ways. I don't think the court is, specifically designates a given term as, this is going to be our abortion term. This is going to be our
like a running theme,
our race term or what have you. And there are voting rights cases every year, it seems like, or gerrymandering or something like that. The ICWA case, the Indian Child Welfare Act case. You can broaden it to be about race and identity, although it really presents separate issues than how race is considered in voting, than how the affirmative action cases. I think the court now, in its current composition, is more willing to take up cases of political salience or higher profile controversies of various kinds than past courts, where neither the left or the right of the court knew where, say, Justice Kennedy was going to be, and so they were hesitant to take some bigger cases. But I don't think it's statistically significant. Probably that this term there, you and other reporters might come up with a theme that it's about identity.
Right. Okay. Yeah. It just seemed like it's, something that race and diversity and identity is part of the political debate. And
it catches our eye, absolutely. But look, just as we're recording this on Monday, November 7th, there are 2 cases being argued about the structure of administrative agencies. So you could spin a tale about how what the court's really concerned about is pushing back on the administrative state and building on last term's West Virginia versus EPA case. Mm-hmm. Lots of things going on for sure. But given that the court doesn't really take that many cases altogether, last term they decided 60 after argument, which is very low. Any one case or any couple of cases along the same line, you can glom onto it as being a theme. But I think, I think it's too much of an exaggeration to say that the court all of a sudden is looking to insert itself into the identity-focused culture wars.
Right. Okay. Well, I guess that also brings not only race culture wars, but coming up next month, there's the, I guess we could talk about LGBTQ identity in that case with 303 Creative. It's a First Amendment case coming up. How big of a deal is that? Is that a lot of our readers are familiar with the Masterpiece cake. This one has to do with a website designer who says she doesn't want to speak against her religious beliefs on her when doing websites for clients, for example, like creating a website for same-sex marriage, that sort of thing. And so I'm curious, how big of a deal is this? Do you think the court could go further in clarifying this kind of First Amendment clash with LGBT rights?
It's 5 years ago in Masterpiece Cake Shop, it avoided resolving the issue of compelled speech or anti-discrimination law by saying that the Colorado Commission, which is also at issue in this case 303 Creative is also out of Colorado, that it was biased in an anti-religious way, and so ruled for Jack Phillips, the owner of the cake shop. In that case, here they're probably not going to be able to avoid it that way. Nor is there an issue of whether cake baking is First Amendment protected activity. Here, clearly, graphic design, creating a website, that speech. I think they will, have some sort of ruling saying that unless it's a monopoly situation, unless really you're not going to get service for your event, that it's akin to, whether you're talking about ancient England or the civil rights era, where if you couldn't get service at a restaurant or stay overnight at a hotel, you were completely out of luck and had nowhere to go for miles and miles around. Something very extreme like that, I think they're going to say you're not going to, you don't have to be compelled to speak in that way. And hopefully that will put an end to these sort of persecutorial lawsuits that have been spawned just to stamp out the last vestiges of politically incorrect viewpoints rather than actually helping people who otherwise wouldn't be able to get served based on some immutable characteristic.
Mm-hmm. And then I guess also in December, there will be more v. Harper, the case over state legislators and their control over elections, or if I think the challenge is what involvement do courts have. What are you looking for there, and what should we be paying attention to during the arguments?
Well, a few years ago, when the court took up the issue of partisan gerrymandering, it ultimately ruled that there is no constitutional standard for determining when politicians use political criteria too much when drawing districts, setting aside the issue of race in the Voting Rights Act. And so here, the question is there a federal constitutional standard for when a state court interprets state election law in a way that isn't mere interpretation, but rewriting and creating new law? It's going to be tough. I don't know what, especially when there are pretty vague state constitutional provisions, as is the case here out of North Carolina. The standard by which the state Supreme Court ruled was one about requiring fair and free elections. Well, okay, is the problem with the state constitution being too broad? Is the problem with the state Supreme Court interpreting it so poorly that it's a due process violation or something? I don't know. It's hard to predict what the U.S. Supreme Court is going to do with this, but it's clearly an important issue because after every election, increasingly we have complaints from both parties that a state Supreme Court is engaged in some sort of shenanigans.
Mm-hmm. I guess my last question for you would be, other than the ones we just mentioned coming up in December, are there any other cases you're paying attention to that I should be focused on? And then also any orders or petitions for cert that have caught your attention?
Well, a couple of cases that have already been argued, the property rights case, Sackett versus EPA, that was argued the very first day of the term, the first Monday of October, that could have significant ramifications for federal regulation under the Clean Water Act. So it could be this term's West Virginia versus EPA, what last term was about the Clean Air Act. The pork producers case about California regulations having a huge impact on the whole national regulatory, the national pork producing and agriculture industry more broadly. What kind of standards are there for state laws that have an extraterritorial impact? That's going to be hugely important, not just for pork production, but in a whole host of areas. I think those are the biggest cases so far this term. I'm waiting to see what they will still grant in the future. The social media regulation issue is the biggest one that's looming. There's a split as between the 11th Circuit, which largely struck down Florida's social media regulation, and the 5th Circuit, which upheld Texas's, in opinions by Trump-appointed judges who generally are well respected, but as a division even among originalists or textualists or conservatives on that issue. And those were decided early enough that the briefing is going to be done in time if the Supreme Court wants to get it onto the docket this term.
Mm-hmm. It is interesting. And I mean, obviously, aside from the law, but just the constant news coming out between Elon Musk and Twitter and his takeover there, I'm sure it'll be one that a lot of our readers focus on once the ruling comes down. But I wanted to say thank you so much for your time. I know you're very busy traveling and with your family, so we really appreciate you breaking this down for us. And then also, I would love to have you back once we do have the affirmative action ruling and can have an idea of how far-reaching it will be and how it'll impact all various parts of society.
Absolutely, Alex. Always good to talk to you. And indeed, I have been traveling a lot, but that stopped now for a few months, as you alluded to this, as my wife and I are about to welcome twins to our family. So we're going to be busy, but I'm going to be at home, and I'm sure having cabin fever and willing to talk to anyone who wants to listen about the court and anything else.
Of course, and congratulations. Thank you. Thanks for tuning in to the third episode of Court Watch. I'll have another episode for you next month where we'll break down how the justices were leaning during arguments in a major LGBTQ versus First Amendment dispute, and a case on state legislators and their control over elections. If you have not subscribed yet, please do so, and also feel free to email me interesting questions or topics you want explored about the legal reporting world. I'll do my best to answer them during each episode. Thanks for listening, and I look forward to hearing from you all soon. Listen to my podcast, Court Watch, at WashingtonTimes.com or wherever you get your favorite podcasts.